Okay, imagine this. You get a letter from your HOA. They're talking about a new budget. But wait, you never even got to vote on it. Sound frustrating? Well, that's exactly what happened to one homeowner in Scottsdale, Arizona. And it kicked off a legal battle that came down to the power of just one single word. So right off the bat, we've got a classic conflict. You've got a homeowner, R.L. Whitmer, who took a stand against his HOA board. He basically said, hey, you can't just pass the 2022 budget without getting approval from us, the homeowners. The board, of course, disagreed, and this whole dispute headed straight for a legal showdown. So how did things get so heated? Well, it all started back in late 2021. The board began talking about the new budget and some kind of ratification process. But Mr. Whitmer, our homeowner, spotted a problem right away. He started emailing the board over and over, basically reminding them that they had to follow the rules in their own founding documents. Finally, the board scheduled a special meeting for everyone to vote, which brings us to this really key date, February 9th, 2022. Now, here's the twist. The vote didn't fail because people voted no. It failed because it couldn't even happen properly. See, in this community of 29 homes, they needed a majority of owners, that's 15 of them, to show up just to make the meeting official. That's called a quorum. Only 14 came, so without a quorum, no official decisions could be made. But the board just went ahead and passed the budget anyway. And that move by the board is what officially kicked off a formal legal petition. The whole thing, every single argument, every legal filing, it all came down to how you interpret one single word. A word that was buried deep inside the HOA's original governing document from way back in 1972. And here it is. This is the phrase at the heart of everything. Section 8.2 of the HOA's declaration says that the annual assessment, the fees every owner has to pay, is to be determined by the council. This one little phrase became the entire battlefield. Everything hinged on figuring out what that one word, council, actually means. And that really is the million-dollar question, isn't it? Or, well, the annual budget question anyway. Does the council mean the small group of elected board members, or does it mean something totally different? The answer to this was going to decide the entire case. And bam! Here's the homeowner's smoking gun. He didn't have to guess or interpret anything. He just read the rulebook. Section 1.4 of the same document spells it out in black and white. The council consists of all of the owners, not the board. All 29 homeowners. From his point of view, this thing was case closed. But, it's never that simple, is it? Despite that definition seeming crystal clear, the HOA board had a totally different take. They basically argued that times have changed and the law has changed with them. And this disagreement is what created the two very different sides of this legal fight. All right, let's break down the two arguments here. On one side, you have the homeowner. His view is super simple. The declaration is a contract. A contract is a contract, and you have to use the definitions in that contract. If it says council means all owners, then all owners have to vote, period. But the HOA, on the other side, pointed to a new Arizona state law, the Condominium Act, that was passed in 1985, long after their documents were written. They argued that under this newer law, the board of directors has the power to act for the association, and that the old term council should be seen as the same thing. So what do? You've got a contract from 1972 squaring off against a law from 1985. Which one wins? Well, it all fell to an administrative law judge to make the final call and settle this thing once and for all. And this wasn't just some internal HOA committee meeting. The decision was handed down by the Arizona Office of Administrative Hearings. We're talking a formal legal proceeding with a decision that is legally binding. The judge's logic was actually incredibly simple and powerful. They didn't get tangled up in decades of changing state laws. Nope. They went straight to a core legal principle. An HOA's governing documents are a contract between the association and its members. Simple as that. And here's the money quote, right from the ruling. The judge sided completely with the homeowner. They said the plain language, the actual words on the page, of the declaration requires a vote by the owners. That original definition of council was the one that mattered. The document means exactly what it says. Then the judge added this one last zinger. They pointed out that if the HOA wanted the board to have this power, they had, get this, over 36 years to update their documents to match the new state law. But they never bothered to do it. And as the judge basically said, their failure to update their own rules wasn't the homeowner's problem. So what was the bottom line? The homeowner won. Flat out. The judge affirmed his petition and ordered the HOA to pay him back his $500 filing fee. It's not a huge amount of money, of course, but it was a symbol of a total victory on a really important principle. Now, this might seem like one little case in Scottsdale, Arizona, but the ideas at the heart of it are incredibly important for anyone who lives in a community association. So let's talk about what we can all learn from this. There are really 3 big lessons here for every homeowner. First, your HOA's governing documents, they're not just suggestions. They are a legally binding contract. Second, you have to pay attention to the definitions. As we just saw, all the power over who gets to do what can be hidden in a single defined word. And third, it is absolutely your right as a homeowner to read these documents and question your board to make sure they're actually following them. The final order really cemented the win. The homeowner's petition was upheld, he got his money back, and, most importantly, the judge ordered the HOA to follow its own rules for all future budgets. The power was officially put back where the original documents intended it to be, with the owners. And really, this whole story leaves us with one last, really important question we should all ask ourselves. This case was won because one homeowner took the time to actually read the rulebook. So, do you know what's in yours?